G'day everyone, and welcome to the third video in week 11 of our Legal Ethics and Trust Accounting course. This week we're looking at the ethical responsibilities of practitioners when they are appearing as advocates before the court. We've already learned that an advocate has a duty to observe the formality and dignity of the court, and with that, a duty not to make out that they enjoy some sort of special favour from the court. We've also learned that an advocate has a duty to exercise their independent forensic judgment in court and that they cannot be the mere mouthpiece for their client. We've learned that one reason for this is to ensure that the valuable resource of time in the court should be used efficiently. In this third video, we're going to continue that theme by looking at other duties for practitioners to exercise responsible use of the court's procedures. The first aspect of this duty is the duty not to bring an embarrassing case. Now, you might remember that we've already touched on this way back in week 4 when we were discussing the practitioner's duty to the court, and I talked briefly about the absurd and embarrassing cases brought in many courts by practitioners who were acting on behalf of the ridiculous former President of the United States, Donald Trump. An embarrassing case is not embarrassing in the sense in which my kids used to tell me I was embarrassing. A case is embarrassing if there is literally no way that there could ever be any outcome of the type sought. A practitioner must be convinced that there is a sound basis for bringing a case before the court before they do so. Solicitor's Conduct Rule 21.1 says a solicitor must take care to ensure that the solicitor's advice to invoke the coercive powers of a court is reasonably justified by the material then available to the solicitor, is appropriate for the robust advancement of the client's case on its merits, is not made principally in order to harass or embarrass a person, and is not made principally in order to gain some collateral advantage for the client or the solicitor or the instructing solicitor out of court. Barrister's Rule 59 is identical. What all of this boils down to is that the only ethical reason to bring legal action is because you genuinely consider there is a case to be put. You cannot bring a matter and you cannot allow your client to bring a matter for other reasons. For instance, in an effort to bully the opponent into a settlement, or in an effort to drag their reputation through the mud, or maybe in an effort to get in the way of other matters, for instance, stalling their opponent's access to finance for a business deal. The reason for all of this, of course, is that even fruitless, pointless, ridiculous cases take up time in the courts, and they put opponents to unnecessary expense and stress and wasted time and effort. This whole idea extends to the actual conduct of a matter as well. Many of you will have already studied civil procedure, and so you'll have already come across Rule 5 in the Uniform Civil Procedure Rules. For those who haven't, the rule goes like this. The purpose of these rules is to facilitate the just and expeditious resolution of the real issues in civil proceedings at a minimum of expense. Accordingly, these rules are to be applied by the courts with the objective of avoiding undue delay, expense and technicality, and facilitating the purpose of these rules. In a proceeding in a court, a party impliedly undertakes to the court and to the other parties to proceed in an expeditious way. The court may impose appropriate sanctions if a party does not comply with these rules or an order of the court. In other words, you can't deliberately go slow on a case, and you need to confine the dispute to the real issues in order to proceed with a minimum of expense. Again, the public policy reason for this rule pretty much seems self-evident. The court's limited resources will be wasted in the event that parties conduct their matters inefficiently or with undue delay. These rules are important, but I want to turn now to some rules where the ethical dimensions are really frank and stark. No doubt you already know that words spoken in the course of legal proceedings are privileged. You cannot be sued, and a witness cannot be sued for things said in court. The reason for that, of course, is to ensure that there are no constraints on practitioners and witnesses arising from concern about, for instance, defamation proceedings brought by an opponent. However, the privilege comes with a risk, and the risk is this: parties or witnesses may be tempted to use the court as a public platform to make baseless allegations about a person in public under the court's protection. This sort of thing often happens in family law members where the parties are hurting and where they truly detest one another, and they'll often say the most horrible things about one another. Many family law proceedings follow from an act of infidelity, and the party who got cheated on really wants to put that on the record. But it's irrelevant. It's irrelevant to parenting matters. It's irrelevant to property matters. The courts will not stand for this sort of abuse of court processes. The rules of evidence allow for the court to strike out evidence that is scandalous. Just as importantly, our professional rules require us to refrain from putting these sorts of propositions. Solicitors Conduct Rule 21.2 says a solicitor must take care to ensure that decisions by the solicitor to make allegations or suggestions under privilege against any person are reasonably justified by the material then available to the solicitor, are appropriate for the robust advancement of the client's case on its merits, and are not made principally in order to harass or embarrass a person. Rule 21.4 then goes on to say, a solicitor must not allege any matter of fact amounting to criminality, fraud, or any other serious misconduct against any person, unless the solicitor believes on reasonable grounds that available material by which the allegation could be supported provides a proper basis for it, and the client wishes the allegation to be made after having been advised of the seriousness of the allegation and the possible consequences for the client and the case if it's not made out. The same rule is effectively made in Rule 60 of the Barristers' Rules. The bottom line is you must not allow the court's privileges to be abused, to make the court an improper forum for sheer personal attacks. It follows from this that you can't cross-examine a witness in a way that represents an improper attack. This might make more sense if you've already done evidence law, but let's see how we go in any event. First up, lots of legal cases really come down to a matter of who the judge believes. And so, when you're cross-examining a witness, one of your goals is often to show the judge or the jury that the witness is not to be believed. This is called cross-examining on credit. And it's tricky because your actual purpose is to show the judge that the witness is not trustworthy. But how far can you go before it's just pure sledging? Well, Solicitors Conduct Rule 21.5 says a solicitor must not make a suggestion in cross-examination on credit unless the solicitor believes on reasonable grounds that acceptance of the suggestion would diminish the credibility of the evidence of the witness. Barristers' Rule 66 is in much the same terms. So it's really down to us and our professionalism. We have to ask questions intended to make the witness look like a bad person who can't be trusted. But we need to ensure that we are genuinely testing their credit, not just giving them a hard time. All of this can have really serious implications for the actual practitioner. A practitioner who brings a hopeless case before the court, or who conducts a case in a way that amounts to an abuse, can find a costs order made against them personally. So the lawyer or their firm or their insurer can be required to pay the other party's costs thrown away due to their abusive process. So here we are at the end of video 3 this week. In this week's videos, we're looking at ethics as they apply in the courtroom. We've learned about the duty of formality, the duty of forensic independence, and in this video we've learned about the duty not to allow the abuse of the processes of the court. This means you can't bring a hopeless or an embarrassing case, you have to conduct matters properly in a way that's mindful of the court's intention to do justice efficiently and effectively, and you can't abuse the court's privileges by making improper allegations about another party under the court's protection. In the next video, the fourth video, we'll be looking more closely at witnesses, how you can and how you cannot prepare them to give evidence, and the proper way to deal with witnesses during the trial itself. 2 videos left to go this week.